Um, Thank you for being one of the founders of Partners in Promise and for adding your expertise as a special education attorney to this conversation.
Here's what's an interesting dynamic. States are required to implement the floor of opportunity that the Individuals with Disabilities Education Act is. They are able then to provide more services and more opportunity, not services, more rights on top of what is already given to you. So for instance, the Commonwealth of Virginia, the school districts are unable to implement anything without a parent's consent and signature. That's not the case when you cross the border into Maryland. When you're in Maryland, which also has a heavy military presence, if you disagree with what the school provides, you have to file due process. That is your only recourse. They can implement whatever they propose. They wait. I think it's something like a month. I can't remember the exact period of time, but after that time elapses, the school districts then go ahead and implement the IEP, even if the parent has signed it in disagreement. Their disagreement simply signifies that we don't agree and we're going to have to go lawyer up and file due process.
So just from let's pretend an individual doesn't really have a frame of reference of what their recourse is, and they are just entering into this kind of battle with a school district. What is involved in due process for contacting representation or not? I mean, can they even go in without representation? Can they, how many months does it take? Is it open-ended? Is it just as unique to obviously the topic we're talking about, each individual student?
Some states, their departments of education, they actually have their own hearing officers, and their decision is pretty much it. Other jurisdictions, the state education agency does not directly, they coordinate due process, but they are not, their employees are not the ones who are hearing officers. Instead, you have, this is the case here in the Commonwealth, hearing officers who are appointed by the state, well, we're a Commonwealth. There's only 4, so at any rate, the Commonwealth of Virginia uses a hearing officer system where the hearing officers are appointed. They're administrative law judges. And some of them, they actually hear cases involving employment law and other administrative laws. So not just special education, whereas there are states, the individuals who are hired through the Department of Education for those states, they only hear special education due process. So there's a bit of a difference and a nuance depending on what state you're in when it comes to determining the outcome of due process. But what remains the same is when you are filing a complaint under the Individuals with Disabilities Education Act, you have a 2-year statute of limitations on which you can file. So if something happened 3 years ago, you cannot file for it now. And also for 504, Section 504 complaints or complaints arising under the Rehabilitation Act of the difference there is you only have a 1-year statute of limitations in which to file. And then for other complaints, OCR, Office of Civil Rights, that's 180 days. And there are other state complaints. They're typically a 1-year statute of limitations. But for due process, for IDEA, it's 2 years. For 504, it's 1 year. And you have to keep those timelines in mind whenever you're dealing with any struggles with the school. If you have an IEP that was proposed, let's say you live in Maryland, and the IEP takes away all support and services for speech language, let's say. If you wait more than 2 years, you're not going to be able to file that case. You have to file it within 2 years. When we're talking about timelines, there's a mandatory resolution period. Well, typically here's what happens, at least in the Commonwealth of Virginia. Once you file a due process complaint, the school district has 5 days to respond and let the Virginia Department of Education know, to then tell the parent what their rights are, and to have a hearing officer assigned. There's a 10-day period during which a resolution session has to be held to discuss potential resolution of all claims short of litigation. The resolution period extends for 30 days, but that meeting has to be held. After the 30-day point, that's when you're talking about the actual due process timeline itself, meaning when documents and, or I should say, when exhibits and witness lists will be exchanged, which is 5 business days prior to the start of the hearing. From after the 30-day resolution, the hearing officer has 45 days to submit their decision. So during that 45 days, usually a hearing officer wants at least 2 weeks to write their decision. So you subtract 14. So now you're talking about really 31 days. And during that time, that's when you need to get your ducks in a row. You need to hire your expert witnesses. You need to make sure that you have all the documents you need. You need to subpoena the school district for what we call subpoena ducis tecum. It's basically a document subpoena demanding those documents that are responsive to specific types of requests that you put into the subpoena ducis tecum, things like IEPs, emails, data collection, any type of communication between the school and the parent, or even amongst the school and other school individuals or third parties about the student. Those are not always emails. Sometimes they are letters. Sometimes there's a phone log or some type of record. Those are all types of documents that you should be seeking out. So during that period of time, you need to get those documents. You need to line up your expert witnesses. And then also 5 business days prior, that's when exhibit lists and witness lists are due. Typically, we exchange exhibits electronically, but depending on really the age of the hearing officer, they might demand that you provide them physical copy. So you also have to think about how long it takes to print that exhibit binder and get it to. Yeah. So there's a lot, it's litigation. And a lot of parents don't realize this because the school district will tell you, well, you can always, if you disagree with us, you can go to due process. And you think due process is just another, I write a complaint about something I don't like and you give me what I want. It's not. It's full on litigation. You appeal to the federal court. You can end up in the Supreme Court of the United States of America on the issues in your complaint. And so many families do try to do this without an attorney or try to do it with an advocate. And it's disastrous. I've been hired by a military Navy family, and they wanted us to kind of try to fix their due process. They'd already gone through the entire litigation. There'd already been a decision written. They had hired an advocate, and it was a train wreck. And so I can only appeal what was raised during the hearing. And that individual didn't know enough. It was heartbreaking. They simply didn't know enough to ask for or to file their complaint under the correct FAPE claims. I mean, you can have a claim under the IDEA for failure to provide a free and appropriate public education because the school district failed to implement a decent IEP, or because the school district denied a child a required area of need, service, accommodation, or because the school district failed to conduct a functional behavior assessment and to give the child a behavior intervention plan. I mean, so there's a whole host of things. And if you don't raise them at trial, you can't raise them in the appeal. And so we have to let clients know when they come to us after a disastrous due process hearing, we are limited in what we can do for them. So what typically happens is, even if we have filed full-blown federal court appeals to the best of our ability, and the school has actually come back and said, let's settle. So even though the parents had to pay this advocate to do whatever it was they did, and it did not go well, and they paid us to do the appeal, it took all that financial and emotional investment to finally reach a settlement, which I feel like we could have done for the client had they come to us at the beginning. And I have to say, there are some excellent advocates. I work with special education advocates on a regular basis. And they typically, when they get to the point of litigation, that's when they come to me and say, here you go. work with this family. I will give you whatever information you need. We've gotten to the point where we can't settle these differences short of litigation.
Yeah.
So my recommendation is, because, well, first of all, most school districts are represented by lawyers. Parents really do need the support of a lawyer when they're going to litigation against the school. And I need parents to realize that due process is litigation.
Yeah. Anything that you think we should cover in the future?
Well, one thing is that I feel very strongly about is this. So there's always
Yeah.
hope. And please surround yourself with other hopeful people. Realistic, of course, but hopeful. And I think Partners in Promise is a great example of a group of very hopeful, forward thinking, special education, military families. We know that there is a potential for solution. We know we can make things better for our children, and that's what we're doing. So that's my, I guess, last word of encouragement.